You haven't said very much about the language of the statute.
Yes, Your Honor.
How do you get, if by reason of a person's failure to vote is not but for cause, how do you get around the language of B2?
Well, Your Honor, the language of B2, I think, strongly supports our position because what it says is you can't have a system that uses non-voting as the reason for purging somebody, except you can use C and D, which is to say you can use the confirmation process. And so non-voting can come into play at the end of the process, not at the beginning of the process.
But that actually isn't what B2 says. It does not say you can't use failure to vote as a reason for removing someone, except that you can do what is set out in C and D. What it says is that the principle that you can't use failure to vote as a reason for removing someone may not be construed to prohibit. So it tells you how to interpret the first part of B2. It is not an exception to the first part of B2.
Right, but it is an explanation that the one kind of consideration of non-voting that it should not be construed to prohibit is the part that comes in at the end of the process. And then they went on to emphasize that the sequence. They say, A, they have not responded to the notice, and then they have not voted for two consecutive elections. That is very clearly what Congress was trying to preserve and to eliminate the tension, perceived tension between B and D in the old version.
It says that it's all right if you followed either C or D.
C and D, Your Honor.
Well, it says you think you have to follow C and D?
Well, I think you need to follow.
That's not what it says.
You need to follow something like C, because clearly Congress anticipated that there would be something that would tell you that they have moved before you go into the confirmation process. Because the confirmation process consists, if they don't get the notice back, of no evidence at all about whether they moved from the notice, and 4 more years of non-voting, precisely the thing Congress said should not be the reason that you purge somebody. So the whole system only makes sense if you assume there's something like the NCOA process or some other indication that they have moved before you put them into the process. And if you don't have that, you're going to vastly over-purge people. That's precisely what Ohio does, because so many people don't vote for 2 years and get put into this process where 70% of them don't send back the notice, and then 4 more years of non-voting.